I'm going to cover the purpose and benefits of pre- and post-civil partnership and nuptial agreements. And just because it's a bit too wordy, I'm just going to refer to nuptial agreements, but by that I do also mean civil partnership agreements. I'm going to cover what to discuss and consider with and ask your client when you're advising them. I'm going to look at how to revise an agreement prepared by another lawyer, what to delete, what to add in. I'm going to talk a wee bit about the importance of soft skills. I'm going to look at how to draft the agreement, what to include, what not to include. Then I'll cover pitfalls and challenges. And finally, I'll look at a review and an update of relevant case law. The agreement is to remain in full force and effect during marriage, subsequent to any separation or divorce, or in the event of death. It can be varied only by supplementary agreement and revoked only if in writing signed by both parties. Consider having a clause to say if part of the agreement is declared unenforceable, the remaining parts remain binding on and enforceable. Proper law, jurisdiction and forum in event of dispute. Now, it is common for nuptial agreements to try to nail down jurisdiction. But, and I know I keep saying this, if you think there's any prospect of cross-border issues, get advice from a good family lawyer in that jurisdiction before you finalise the agreement, because we don't know how they'll be interpreted. When is challenge possible? So we've got provisions under contract law. So broadly, defective contracts, force, fraud and fear, facility and circumvention, undue influence, error, misrepresentation, frustration, for example, where something happens which relieves parties of their obligations under the agreement. Now, I've skipped through those because that's not normally what we would be looking at, where we have a nuptial agreement and a challenge is sought to it. As family lawyers, we will more typically come across Section 16 of the 1985 Act,